Welcome, class. By now, most of you would have seen and understood the substantive content of intellectual property rights. For instance, what is a patent? What is copyright? What is trademark? What are the limitations on each of these rights? And so on and so forth. But it's one thing to understand the law from its substantive point of view, as in what the content of the law is, and quite another to understand the ways in which one can enforce these various rights conferred by the law. How do you enforce a copyright? Suppose you have a patent in respect of an interesting technology. How do you stop somebody from infringing on your patent? In law, what are the different remedies that you have? What do you ask a judge, in other words, and in simple terms, as to what you need to protect yourself and your interests? So, in this module, we are going to look at four important kinds of relief that the law guarantees and the different ways in which these reliefs operate to protect the plaintiff. The plaintiff here is the person who sues to enforce his intellectual property rights. What are these four important remedies? The first is, of course, injunctions. Then there are damages and exemplary damages. And then there are Anton Piller orders. And of course, there is rendition of accounts as well. So these are broad remedies that the law uses to protect your intellectual property rights. Why are these remedies important apart from the simple practical question of how do you enforce your rights? From a conceptual standpoint, these remedies are also important because they give us a strong insight into the kind of right that property is or intellectual property is. Finally, the key word here is property when you talk of intellectual property rights. So, when within the structure of property there is violation of a right, what the law seeks to do is simply, in some sense, to bring about corrective justice. So there is an equilibrium, and that equilibrium has been violated by the act of infringement. What the law does is restore the parties to the position in which they would have been had that equilibrium been maintained, and this is corrective justice. So through these different remedies, we also get a sense of the structure of substantive intellectual property law from a conceptual perspective. What does it mean to have a right? And what does it mean when somebody is said to violate that particular right? What is this equilibrium that we are speaking about? So these are also questions to which we find answers through this whole process of looking at the different remedies that intellectual property law accommodates. So diving straight into the first of these remedies, and clearly the most important in terms of its effect, in terms of what it can achieve for the parties, let us start with injunctions. Now, injunctions are nothing but a restraint or a direction. So they can either be a restraint, in which case they are prohibitory in content, or they can be a direction to do a positive act, in which case they are known as mandatory injunctions. Again, injunctions are granted both at the interim stage of the proceeding and as a matter of final relief. This requires a little bit of explanation, and which is what we are going to look into for the next couple of minutes. So, let us just use a hypothetical. A is a film producer. He has produced a film title X. B, without taking A's permission, remakes film X in another language. Now the script in film X also has been assigned to A. So owner is A as far as both the script and the film are concerned. A files a suit against B. Now B's film, let's call it Z or Z, is currently under production. In fact, it's finished, completed the production and is in the post-production stage and is out for release in the next couple of weeks. But the trailers and the promotional material of the film is out. Watching all of that, A is certain that B has basically remade X and created Z. Now what does A do? Of course, A can file a civil suit, and that's what in most of these cases happen, at least at the level of civil remedies. So fine, A does file a suit. Now what does A ask? Obviously Z has not released yet. So there is no financial loss that A has suffered for the moment. Except of course the loss that he would suffer simply because nobody else is going to acquire the remake rights for X in that particular language in which Z is being made. But more than that, A's huge concern is with the release of the film Z, because once Z comes out, that's when he's going to suffer this loss, the real financial loss that nobody else is going to take remake rights in respect of that film. Now, we all know that a civil case can typically go on between an average of 6 to 10 years. So what A seeks in the case as a matter of final relief is something that he is only likely to get somewhere between 6 to 10 years from the date of filing the suit. But is that what he wants? No, he wants to stop the release of Z immediately. So what does he do? He applies in the suit by way of an interim application and seeks for what is called an interim injunction or a temporary injunction. So this is something granted during the pendency of the suit. So by the very nature of interim reliefs, they are granted at some point between the date of initiation of the suit and the date of final disposal. Now these interim reliefs can be of various kinds, but the most important is that of interim injunction in the context of intellectual property rights especially. We also need to keep in mind the simple fact that with intellectual property rights, the shelf life of the right is very limited. Yes, it's true that the duration of the right is pretty long, especially in the case of copyright. You could say life of the author plus 60 years. But let us look at most content today. For how long do the public have an interest in a book? For how long do they retain interest in a film? So, as a matter of time, intellectual property rights have limited shelf life. As a matter of monetary value, again, customer preferences or consumer preferences change. You make a movie that is suited for the time and the occasion now. In another 20 years, if it's a classic, yes, there will be people watching it, but if not, nobody will care. You make your money and you move on. The same applies to a book. Same applies to computer software. So most content today that we have is dated by virtue of limited customer attention span. So can you wait for 7 or 10 years to really stop somebody from remaking your film? When the consumer interest in your film is current, and in another 10 years trends may change and there won't be any takers for your film. So considering all this, interim injunctions become very important, even more important in the case of intellectual property rights, I would say, than with other areas of substantive law. Now, in interim injunctions, as mentioned earlier, there are both prohibitory and mandatory injunctions, and we are going to look at both. But before we get into that, an important clarification is in order. When it comes to the substantive law governing permanent injunctions, we have to turn to the Specific Relief Act. But on the other hand, when it comes to the substantive law governing temporary injunctions, it is governed by the Code of Civil Procedure. So the Code of Civil Procedure is what we will look at first, and then we will proceed to the Specific Relief Act and final injunctions. Though the law, in terms of the factors the court has to keep in mind while granting the injunction, remain almost the same, both with temporary and permanent injunctions. So permanent injunctions are the ones that are granted at the end of the suit after trial, which is a final relief, and interim injunctions are by way of interim relief. So what are the different factors that the court has to keep in mind while granting interim injunction? That's the first point of concern for us. The court has always characterized its approach to the grant of a temporary injunction using three factors: the existence of a prima facie case, balance of convenience, and irreparable hardship. Let's look at each of these factors. What does one mean by a prima facie case? This by itself is a pretty ambiguous expression, and it can mean different levels of convincing required on the part of the plaintiff. Is it a strong prima facie case or is it a weak one? The various degrees of proof required to establish these different levels of standard within the same terminology make it a pretty fascinating area of discussion in itself. Now, looking at intellectual property rights, as I mentioned earlier, a lot of the adjudication happens very early on because nobody has the time to wait. The court has to arrive at some strong view regarding the merits of the case, regarding who deserves to win, very early on, because the value, as I said, the shelf life of the property is pretty limited. Moreover, if the court were to refuse to grant an injunction when there is already an intellectual property right vested with someone, that could result in the right itself being rendered absolutely redundant. So these are various factors that the court does keep in mind when considering the injunction application. And prima facie case, to that extent, is largely a strong prima facie case in the case of intellectual property rights, because the court has to strike a balance between, one, the interests of the intellectual property rights owner and ensuring that his property right is not rendered redundant, and two, that it is not a frivolous case and no defendant is put in a hapless position where he is unable to do something just because there is, on the face of it, an intellectual property right enjoyed by the plaintiff. So, coming back to our hypothetical, it is not enough for the court to arrive at a conclusion that there is copyright in respect of film X and which is enjoyed by A. The court will also have to arrive at some prima facie conclusion that the film Z is indeed a remake of film X. And this cannot be a weak indication, because by arriving at this conclusion, the court is almost going to restrain the release of film Z. And if it is doing so, it better be convinced, at least to a strong degree of certainty, before granting such an order. So, as far as the prima facie case is concerned, the court does normally prefer a strong showing of prima facie case, a strong showing of existence of the intellectual property right, and a strong showing of infringement of that right by the defendant. Of course, this will not be a watertight showing because the court does not have any of the evidence yet before it. It is only looking at affidavit evidence, conduct of the parties, and basing its judgment on that. The next part of the test is to look at the balance of convenience. Now, what really is the balance of convenience, or to be more correct in our characterization of this part of the test, balance of inconvenience? The real question here is who is inconvenienced more by the conduct of the other party, and who is inconvenienced less by the grant of the injunction or the refusal, as the case may be. So, in other words, you take the plaintiff, look at what hardship or inconvenience will be caused to the plaintiff where the injunction refused. Then take the defendant and look at the hardship caused to the defendant if the injunction were to be granted. You compare and contrast these. Again, look at the conduct of the parties. Look at who on balance has shown better conduct. So the most important part of this test is of course focused on the consequences, but the conduct is not immaterial. And why is this so? It is so because injunction has always been an equitable remedy. It works based on the equities of the case at hand. For instance, if A, in the hypothetical given here, was aware of B making Z for the past 6 months and did not approach court or contact B relating to the making of film Z, A decided to sit and wait and watch. This could result in a classic rent-seeking problem. When right at the last moment, when B is about to release his movie, A lifts his hand up and says, "Come on, look at me, I have got an intellectual property right here. But what were you doing for the last 6 months?" So delay can be an extenuating factor which can work in favor of the defendant. And the court may very well tell A that you didn't act at the right time. Or A were to approach the court without disclosing all the facts. For instance, the fact that there is no assignment of the script in favor of A by the script writer of film X is a factor that can heavily weigh against A, because he is then not the right owner at all. But were he to conceal this and try for an injunction, that's a factor that the court can definitely hold against him, and for suppression of material fact, an injunction can be refused. So these are the different factors that have to be balanced out against each other. Factors of equity and factors of consequence. And this is how we get the balance of convenience or inconvenience test explained. The third aspect is irreparable hardship. Now, what is irreparable hardship? In simple terms, it is hardship of the kind that just cannot be compensated by payment of monetary damages. So we really are speaking about a situation where if injunction were to be refused, the loss suffered by the plaintiff would be of the kind where he could not be compensated by payment of money. Again, let's go back to the hypothetical. The value of movie X is not necessarily quantifiable, and certainly not the remake value. A may decide to remake X in the same language as the one in which Z is being remade, and A may decide to have a better actor, A may decide to do it in a better way, or A may decide to do it worse than what B has done with Z. So it's very difficult to kind of predict the monetary value of an intellectual property right. And due to this inability or difficulty in predicting the monetary loss, in normal situations, we have to arrive at the conclusion that most injury caused in the field of intellectual property rights infraction amounts to irreparable hardship. Hardship that cannot be quantifiable in money terms. So once these three conditions are satisfied, the court can now say that there is a strong case for the grant of a temporary injunction. Now here too, there is a clear distinction between a prohibitory and a mandatory injunction. Now let us be very clear that both sorts of orders can be passed by the court even at the interim stage. There is nothing that stops the court from passing a mandatory direction rather than a prohibitory order. For instance, film Z has not been released. There, the relief sought by A would be to prohibit B from releasing film Z or conducting post-production work. But what if film Z has been released? Does the court have the power to take the film out of the theatre? Technically, yes. The court has the power to prohibit distributors from communicating the film to the public. That would be a prohibitory injunction. Or it can ask or direct B to perform certain tasks which ensure that A's right is not violated. So there can be a direction given to a party to do something. This is commonly done in the case of trademark violation, where two marks are identical or similar. The court feels that there is distinctive similarity, but it feels also that instead of prohibiting the party from using that mark, it can actually direct him to make a modification. The defendant can modify his trademark in such a way that it does not look distinctively similar to the mark of the plaintiff. That would be a mandatory injunction. You are directing somebody to do something. Now, mandatory injunctions are definitely riskier than prohibitory injunctions because you are actually asking a party to alter the state of affairs that he is in currently. And when the court does so, it has been held through a spate of judicial pronouncements that it must be extra careful and it must look at a very strong prima facie case. Unless it is convinced that there is a very strong prima facie case, or a strong case rather, more than prima facie, a strong case that the plaintiff is entitled to this relief, unless that's shown, courts will be reluctant to grant the mandatory injunction. Before we move on to the next topic of damages, a quick word about the procedure once an ex parte injunction is granted. Now, an interim injunction can be granted even without hearing the other party, and that is called an ex parte injunction. Now, even among injunctions and ex parte injunctions, there is something called a key timet injunction. It's spelled as QUIA space TIMET. A key timet injunction is where no real damage has occurred yet, but there is an apprehension of damage or injury. The hypothetical mentioned through this lecture is an example of a key timet injunction being sought. Now, in some cases, the party may be of the fear that if the other side, that is the defendant, is aware of the litigation against him, he is going to release the film in advance and thereby ensure that an injunction does not fall to be of any great effect. In order to get over this it is open to the plaintiff to move the court without notice to the defendant. And the court can indeed grant an injunction without hearing the defendant. But in a situation like this, it is imperative on the part of the plaintiff to intimate the defendant of the order of injunction within a period of 24 hours from the date of grant. And the defendant then has the right to move the court to vacate the ex parte injunction. So ex parte injunctions are granted on standards pretty much similar to the grant of a normal interim injunction where both parties are heard, but with the additional caveat that the plaintiff has to intimate the defendant of the order in question within a period of 24 hours along with a copy of the typeset of papers in the case. Now we can proceed to a consideration of the other remedies that are sought in the case of intellectual property rights infringement. The most important of these is, of course, damages. Damages are a situation where one suffers loss and the loss can be compensated in money terms and a certain sum is fixed. Now, how does one compute damages? Again, a pretty complex question, and in this lecture we are not going to look so much into the nuances, but broadly there are three kinds of damages that we must bear in mind. The one most common is normal damages, where the attempt of the court is only to put the parties back into the position in which they would have been had the infringement not occurred in the first place. So here again, the court can either compute the loss suffered by the plaintiff and ask the defendant to pay that loss, or it can even look into the profit gained by the defendant as a result of the infringement and direct the defendant to keep an account of its profits and in the ultimate analysis compute the same, and based on the choice exercised by the plaintiff, either grant compensation for the losses suffered by the plaintiff or direct passing over of a percentage of the profits earned by the defendant. So the latter kind of relief is basically called rendition of accounts. So in many cases the court, even at the interim stage, and largely in cases where it is not fully convinced that granting an injunction would be fair to the defendant, as in it has its doubts as to whether such grant of an injunction would be fair at all. In such cases the court can, and the court does, still give some relief to the plaintiff by way of directing the defendant to maintain accounts. And in ultimate analysis, once the trial is over, if the court were to come to the conclusion that the plaintiff is indeed entitled to damages as a relief, the court can ask the defendant to furnish the accounts that it has maintained thus far, and then either compensate for the loss suffered by the plaintiff, or ask the defendant to pay some part of its profits to the plaintiff. So this is how ordinary damages work. But over and above this, we have a category called exemplary damages. The idea behind exemplary damages is simply deterrence. The court is really looking here to deter the party and also other third parties, the infringers who are watching on the sidelines. So the idea is to send out a strong message. If you are the kind of defendant who, eyes open, decides to violate the intellectual property rights of a plaintiff, we are going to come down heavily. We are going to impose the kind of damages that is not really serving the purpose of compensating the plaintiff as much as deterring everyone from playing fast and loose with the law. This sort of exemplary damage payment or order is not uncommon in the Indian legal system, especially post the early 2000s. Courts in India are very receptive in cases of willful infringement of intellectual property rights, especially in software piracy cases or in trademark counterfeit good cases, to impose such hefty damages. So exemplary damages today are, though not the norm, certainly a practice witnessed on the ground. As to the deterrence effect of these orders, I personally feel that in computer software piracy cases, many commercial organizations today, much more than the personal use licenses, many commercial organizations are quite apprehensive about using pirated software, because if there is any sort of discovery of that, one, they could pay exemplary damages, and two, and this is what we are going to discuss at the very end, and that is the next, we are just moving into that now, the court can grant an Anton Piller order, and this is a very serious order, especially when it comes to commercial organizations. So what really is an Anton Piller order? It is not an order meant to deter parties, unlike an exemplary damages order, but it does have a significant deterrence effect today, the way it is being operationalized. So in an Anton Piller order, again it's a matter of interim relief, wherein the court appoints an advocate commissioner to go and search the premises of the defendant, to seize infringing material if any, and to report back. So it serves a very important purpose of preserving the evidence of infringement, because in many cases what happens is that once a suit is filed and an injunction obtained, the defendant can very well destroy the infringing material and then say that he never committed infringement, and this is particularly the case with computer software. You can easily delete the software from your system, you can uninstall it. So how is it that the court can ensure that what the plaintiff says is absolutely true and that the evidence is preserved? It is with this narrow objective in mind that the Anton Piller order was fashioned in the first place. But today, the way the order is being operationalized, it can also at some level amount to a threat. Why is this so? Because the advocate commissioner is granted the power to search the premises and not only gather the evidence and prepare a report, but also seize hard disks and other material which can prove the evidence of infringement later. As a result, the entire business of the infringer or alleged infringer can be put to a standstill. and there is therefore the large apprehension and threat that one will have to suffer extreme consequences for use of pirated material. Due to the grant of these Anton Piller orders, therefore, I personally feel that there is increased apprehension of being caught on the part of commercial entities especially, and if being caught, being put to the kind of hardship that an Anton Piller order does put you to, so parties are a lot more careful. So this is where we stand today when it comes to the various remedies in civil law, that is in civil proceedings, for enforcement of IPRs. Before concluding, I would just like to add that finally, as much as we can confer substantive rights of different kinds, the real protection of intellectual property, its efficacy, even its fulfillment of its underlying objectives such as the incentives function and the production function, all of it depends on how effective the remedies of enforcement are. Thank you.